Loud and clear, right? So far, can hear me and can see my screen.
Yes, doctor.
Okay, we are going to start with first question. Okay, first question. Okay, first of all, you must read the question and try to understand who are the parties that you need to advise. This is quite important. Okay, and the question number one, A, invites you to discuss the burden and standard of proof on two parties here, happy and grumpy. Okay, why you need to discuss these two parties? The reason are being you want to pursue the claim or make a good defense. So this is the goal given to you. Okay. This case or this question itself involve multiple parties. So you must start to organize your thought by laying out the relationship of the parties. Very important. Don't get yourself confused. Maybe I will just summarize the whole case for you. Okay, first and foremost, Happy Bank as the prospective claimant or plaintiff here had actually borrowed 300,000 ringgit to Grumpy for what purpose? For, let me just, okay, for the bridal boutique that probably he got interest together with his girlfriend, Senorita. Okay, and in return, multiple people join now. Okay. In return, this bridal boutique actually engaged with one bozo, as you can see. From the scenario itself, it doesn't mention about the role, but I suppose he plays a role as an architect or a project manager in a construction industry. This is how. And his role is very simple. When he issue a certificate of progress, the bank will be authorized to pay miser. Okay, this miser or miser is actually the one that helped to renovate breeder boutique. Okay, on top of that, we have a lawyer named Genocide and also Beast as the employee of Happy Beast, Happy Bank. Okay, so the nexus of the parties in a very simple way is that the plaintiff here, because he will commence the action if you have read the question. So Happy Bank will be the plaintiff and the defendant will be Grumpy, the sole borrower of that particular facility agreement. Okay, and the cause of action here also is very clear. It's because Grumpy default the loan. And third parties actors that was not being sued here, Miser, the contractor, Bozo, the one that issue certificate, Beast being the employees of Happy Bank, as well as there are two bystanders, I mean passerbys lah, Genocide, the lawyer, as well as Senorita. And return, in return, Grumpy actually counted, I mean, they put on his defense premise on a few issues. Number one, Miser forged the certificate. So Miser is the one that create forgery about this certificate of progress. And second issue that he raised is that Happy's bank own negligence had caused the loss, not because of the breach of the loan agreement. Okay, by having looked at the question, now you should be able to make out that you need to discuss about the burden and standard of proof of each party, isn't it? In order for them to win the case. But what I need you to remember is that this is a practical question. The question does not just ask you to talk about the general principles of legal burden as well as standard of proof. It is not, you have to relate directly to the facts in order to stand out. Otherwise, your answer itself will be a regurgitation of what you have memorized. You do not put the thing into practice. Okay. I formulate my answer in such a way. Okay. Under Section 101 of Evidence Act, this one we all know already. Happy as the plaintiff must prove all the primary facts constituting his claim. So what is his claim? Breach of the repayment of loan agreement. Okay. And the plaintiff will bear the standard of proof on balance of probability to prove the case. Okay, and then you further elaborate what does it mean by proof, referring to the case, landmark case. This one must remember, Jayasena, as well as Section 3 of Evidence Act to define the wording proof, okay, which means legal burden of proof, not just evidential burden. Okay, and then you start to discuss section 102, and you have to teach Happy what to do, because section 101 and 102 itself is just principle. How do you want to go on with the case? That one is very important. So you have to mention, okay, first thing, existence of an enforceable facility agreement. Because like those who had attend my classes 2 days ago, you must have known, in order for you to prove a breach of contract, first there must be a valid contract. Same issue here. To discharge this sort of legal burden, under section 102, Happy must tender original stamp loan facility agreement. So this is how you think already, because you must know, if the question asks you just to discuss the general principle, it will not give you this sort of facts because it will be deemed irrelevant, isn't it? They will just ask you to discuss, give me the general principles of burden and standard of proof for plaintiff and defendant in civil case, isn't it? Why they want to put up the whole story and confuse you? So this is how you play along with this principle. Okay, first, proof there is a contract or loan facility agreement and how you prove it. Okay. The second thing is you must prove there is actual disbursement. You release the money to this miser already. Okay. So how you prove is that you must you don't have to be too I mean thorough and speculative. Just say something that is commonly known in the practice. So electronic transaction, bank statement, for example, can be proved under section 90A. And oral testimony of bank officer can come to court to say that, look, the bank had executed this loan by releasing it to miser on such date, like that, oral testimony. Okay, and subsequently, you have to prove the default on part of Grumpy, isn't it? So what you do is you must show the statement again, that this from the account of this particular lender, Grumpy, he default the payment. There is no payment received so far. And a formal notice of demand will actually help you with this case also. Okay, because you did not actually pursue the matter straight away. Okay. And after that, you have to also prove interest. Otherwise, you will not be able to claim. Okay. You get me, eh? So if you look at burden of proof and also this, the legal burden of proof, this is shifting thing, I mean, It doesn't just be static in nature, but this is a moving forward thing, like a scale, macam timbang tara. Okay. When you have put whatever the evidence in favor of your case, for example, you already tender the loan agreement, you can show the default, you can show the release of money. These burden tilts in favor of you. Okay, for example, you are happy, correct? So now Grumpy should be very worried because in order for him to discharge his need to win the case, he must rebut all the burdens that shift to him. Okay, you can understand me. So at this moment of time, you can conclude if the court accept those proof on balance of probability, that means more than 50%, more probable than not. Then prima facie case on part of happy is complete. Be a bit clear, and this burden shift to grumpy. You can refer to this classic case also lah. Leishmanian Chitia against Secure Plantation. Okay. After that, after that, you must say the default. Okay. The default, I mean the grumpy punya legal standing is that, okay, I default the loan, but he pleads that Happy itself is negligent because why? He accept the forged certificate. Okay, so therefore, the Happy Bank lose the right to enforce this loan facility. You must be clear. You must be clear. Grumpy is merely raising defense in this particular issue, correct? So he did not actually pursue a counter claim. So this is not a fresh action. Okay, tak ada counter claim. It's just defense. Okay, but the defense that he raised is a form of affirmative defense. It's not just say I didn't know, I don't know, I deny that, but he's raising some sort of evidence. So what you need to do is you must refer to section 103. Okay, you can also, because 101 itself is a general provision, you can read together with section 103 to say that the legal burden of proving this particular fact, particularly negligence plus forgery, lies on Grumpy. Okay? So what you need to do is to tell, because I don't want you to repeat the same argument for general principle. So what you need to do at this moment, because the facts have given to you, isn't it? There is some evidence for you to release Grumpy from this sort of legal burden. You must make use of it. So forgery, how to discharge this sort of burden is that you have this in your question scenario. So number one, you can tender the WhatsApp apology by Miser because Miser had already said that or admit that he did the so-called fraudulent act. He did a forgery. So this is relevant under Section 21 of Evidence Act. And this WhatsApp messages is actually what we call, I think is uh, this WhatsApp messages is relevant under Section 98. Okay, you can use the case of digital evidence like PP against Nana Segaran, or you can use Ahmad Najib. You can use There's one Mok Ching Yi case as well. Okay. And second thing is one admission will help you. And second thing is the forgery itself, you can prove with various way. Okay. You can compare the signature. You can also ask expert from Jabatan Kimia, Malaysia, to say that this sample of signature or specimen of signature is forged, or you can get someone that is close acquaintance to Bozo to say that this signature is not him. Okay, as simple as that. You can use the case of Shembaga Wali. So this is how you discharge the legal burden in forgery, okay, as a whole. And subsequently, you must also remember there's a negligence issue. Okay, so Grumpy here must actually prove Beast failed to exercise reasonable skill and care owed by a bank in scrutinizing the drawn down of document. Okay, so what you can do is you can actually subpoena Beast to give oral testimony. Alternatively, because the text itself said that Beast assists Miser in the withdrawal, isn't it? But I'm not sure what does it mean by assistance. Does it mean they conspire together, they collude together to cheat the bank? That one we are not too sure. So you can actually also plead in alternative saying that you can rely on Miser's WhatsApp message to say that, look, the bank, your own employee has something wrong. Okay. In any event, you can also call an expert in this banking industry to say this is not appropriate in the practice. Okay. And the standard of proof on Grumpy is lie on balance of probability, even though forgery is actually a criminal act. So one landmark case that you must cite is Sinaya and Sons against Damai Setia, which made out that in all civil cases, regardless how it contains criminal nature, it must be on only a single standard of proof, that is balance of probabilities. Okay, and a keyword that you can use is the doctrine of prospective ruling, means any cases that decide after this Sinaya and Son all use these principles of balance of probabilities. Okay, so in conclusion, so how you make out the case is that, okay, Happy Bank must prove loan exists, disbursement, default, and amount of the loan owing on a balance of probability. If it does so, the evidential burden shifts. Whereas Grumpy allegations that the bank negligently released the loan because due to forgery is the affirmative defense. So under section 103, he must prove the forgery and the bank's lack of due care. Again, on balance of probability. If let's say, for example, if he could have discharged this burden, the whole debt could be reduced, or even be defeated. Okay, if it does not, the judgment will definitely go to the Happy Bank. Okay, very simple, but don't just my reminder to you guys is don't just copy and paste from the textbook about the general principles of legal burden, standard of proof. It will not help you too much, because you must understand this is a question, this fact-based question. So whenever you have this sort of question, all you need to do is uh, to write according to the facts. Okay. And second issue is that whether Happy can call Senorita to give evidence of her discussion with genocide. Okay, So be clear who is Senorita first. Okay. And what is the so-called the purpose if Bang wanted to call Senorita to the court? What is the reason? Okay. So you must make out Happy Bang would be calling Senorita to prove genocide's legal opinion. So from the fact itself, you know that Grumpy is liable to pay the loan. So this is like a indirect admission on part of the lawyers of Grumpy that Grumpy is should have paid the loan. Okay, admission itself is a very powerful tool in civil case in which it helps you to save a lot of problems to prove the default. So meaning to say, if you have this sort of evidence in the court, your case will run smoothly. But now, but now you have several problems. Genocide is not coming to the court, isn't it? So whatever Senorita is going to tell the judge will be genocide told me Grumpy is liable to pay the loan. But this word, Senorita quoted genocide. The maker is not coming. And Senorita is not the maker lah of this sentence, isn't it? But somehow or other, if you look at it, it sounds like a hearsay rule. But you must remember, Evidence Act sometimes is drafted in a way to facilitate the convenience of the operation of evidence. So confession admission itself is actually a hearsay rule exception. So this one you must remember. And some more from the drawings that I gave you just now, Senorita is a person interested as she owned this bridal boutique, isn't it? So she's also closely connected to the subject matter of the suit because the whole subject matter itself is about where is this 300,000 ringgit? Okay, should Grumpy pay or not? So the subject matter is about the money, isn't it? So Senorita will be deemed as a person interested according to Section 17 to 21 of Evidence Act. Okay, since since Senorita itself is a person, isn't it? If it comes to court, you must you must evaluate. Okay, so first you talk about whether relevancy lah. I would say relevancy part is fulfilled or not. Section 17 to 21 is well covered in the relevancy chapter. So this is a piece of relevant and evidence. No dispute. Okay. Second thing is that you must talk about competency. Okay. Senorita is a person, so he will be deemed to be a competent person unless the facts suggest that there is some form of incapacity. For example, unsoundness of mind. But nothing on the facts suggests so, isn't it? So she is a competent witness. But after you talk about the competency of this senorita, you must evaluate, is there any law that stop senorita or stop, prevent, prohibit or bar senorita to give such statement that is so incriminating the case of Grumpy in the court. Okay, any privilege provision that we can rely on or not. So this is the next step that should be considered in your answer. Okay, so now we look at Senorita. Senorita is not a lawyer, correct? Genocide is the lawyer. Okay, Section 162 is only for lawyer, legal advisor. Genocide only can seek protection from this proviso. So this proviso, section 126, will not help grumpy case. Okay, so you can dismiss it quickly, but you have to probe further. You have to probe further, whereby under the legal privilege.
Doctor, your line was lagging. Your line is lagging, doctor.
My line lagging. Wait. Just for a while. Now can hear?
Yeah, just now the whole thing cannot hear.
The whole thing cannot hear.
Oh, start
Yes.
from the genocide there.
Okay.
Saying section 126 and then genocide is bar on that.
Okay. So now you can see who is the lawyer in the picture. Genocide is the lawyer, isn't it? So Senorita, she herself is just the girlfriend that go to consult the lawyer. So section 126 itself only protects the legal advisor, for example, lawyer, from disclosing the confidential communications uh, without this grumpy's express consent. That means a lawyer cannot actually say anything in the court. So this is some sort of immunity that is given to the lawyer. So this is not applicable to senorita. Okay, remember, but in extension of this legal profession privilege, what I need you to look is this particular section. Section 129. Section 129, the coverage is broad. Anyone that receive legal information, particularly about this litigation case, because you must see from the fact is that Senorita actually consulted genocide for what purpose? To discuss the current case with Happy versus Grumpy, isn't it? So this piece of information will actually, the privilege will extend to her. So she will not be compelled to disclose in court that this what we call the Grumpy is liable to pay the loan. Okay, you can refer to case of Wang Hanlin against HSBC. Okay, as simple as that. Okay, so this is litigation privilege. But don't forget, I think it's worthwhile also to talk about section 122 of Evidence Act, which is about the communication during marriage, because the relationship is given, it's girlfriend. So probably the this is just speculative. That's why I put it very short. I would say that this is not applicable because Senorita is just Grumpy's girlfriend. But if you don't put, I don't think you'll be penalized. But the most important is this one, section 129. Okay. So in summary, Happy will have the right to subpoena Senorita to give evidence, but whether she can be forced to disclose the substance of genocide remark, I don't think so. It will be barred, okay? It will be barred pursuant to section 129 as discussed. Okay, so this is how you approach, because number one, the the evidence itself must be relevant first. If not relevant, then you don't have to go a lengthy way to dismiss this sort of evidence, because you can tell the court, I object because nothing is relevant here. Whatever the evidence is not relevant, it should not be admitted by the court. If it is, since it is relevant, then you move to talk about the competency and as well as the compatibility issue, as well as the privilege. Okay, so this is how you should approach the case. Question two, I think is a bit difficult. Um, for the understanding of a student because it talks about how do you want to help the accused to appeal against the conviction and sentence and say that there is a miscarriage of justice which had occurred during the trial. Okay. On the surface of, if you analyze the question itself, okay, first you give the brief facts, isn't it? The accused was charged in magistrate for section 39A, Dangerous Drug Act offense. And the principal argument for this appeal is actually premised on what issues? Number one is that the final prosecution witness before any prima facie case is made out, who is Andy, had been declared hostile without the compliance of mandatory procedure in Evidence Act. Okay, so this is number one. And second thing, the impeachment itself was done without any supporting of prior statement. So we don't know what is the discrepancy the DPP said. So the impeachment is just done like that. So which is not lawful. And the third element is that the defense counsel was not given an opportunity to cross-examine Andy. So these sort of things in combination had caused the procedural fairness was not observed in this particular criminal trial. Okay, so how do you want to go about each issue? Okay, you should made out by now. This is some errors in the impeachment proceeding. Okay, I will do the following submission because this is a appellate process. I will say that the learned magistrate had failed to observe section 145. So section 145 had given opportunities for parties, the so-called parties. Let's say, for example, I am this DPP. If I call Andy to give evidence in the court, suddenly he turned hostile and becomes very negative, adverse to my case, that I will lose this case because of him. By right, whenever you call your witness, your own witness, you can only do examination in chief. Then subsequently, your opponent, the defense counsel, will do the cross-examination. Then after the cross-examination, you have a chance to do the re-examination to repair whatever the wrong information or the technical mistake that your own witness committed during cross-examination. So this is the whole process. But in situation whereby you have a hostile witness, you can actually use leading question to ask him why your statement is different from the previous one. So this is how, okay. And landmark case, you can use Datuk Mokhtar Hashim and Datuk Sri Anwar Ibrahim. Okay, actually, in Criminal and Evidence Act, if you do know, mostly you can use Datuk Sri Muhammad Najib case or Anwar Ibrahim case, because they have extensive coverage of procedural rules, inclusive of Evidence Act as well as your Criminal Procedure Code. Okay, whenever you do know, you cite those cases, you will not be too wrong. Okay, so here, although the prosecution assert that Andy had actually resolved or departed from his recorded statement, the document was neither shown to him nor or tendered. Okay, so the declaration of hostility, okay, if you look at section 155, okay, you open up 155, you can see there are three conditions whereby a witness could be impeached. if their credibility is unworthy by a new person that believe that this guy cannot be believed, has this statement is totally wrong one. This is one. And then subsequently B, there is some form of bribery or corruption. You can show the bank in slip lah, from probably the accused bank in 1,000 ringgit to Andy. This proof you can prove by section 155B. Or third, and that is 155C, you must prove to the court how was his previous recorded statement. Okay. And in PP against Muthusamy, okay, this is what is going to happen during an impeachment proceeding. Okay. If let's say DPP witness Andy start to give different statement, so DPP will stand up and then tell the court, I will ask for an impeachment process. Okay, I will need to cross-examine Andy. The reason is because from the previous section 112, rakaman percakapan ada perbezaan yang ketara or material discrepancy lah. Okay, from the statement that he gave in the court as compared to the one that he gave to the police. Okay, after that, what is going to happen is that the magistrate will require, okay, biar saya baca rakaman percakapan dulu. Okay, he will read, and he will compare. Okay, let's say, for example, in this case, probably Andy is going to say, I did not see the accused have the drug in his premise or in the car. I did not see. But actually, in his previous recorded section 112 statement, he mentioned clearly to the police that he saw with his own eyes the accused put the drugs inside the booth of the car, something like that. So this form this material discrepancy. Okay, then what will happen is normally this the magistrate will ask ask Andy whether you admit you make contradictory statement or not. Okay, and what is the reason you do so? So this Andy will be given an opportunity to explain what is the reason that he depart from his original statement. Okay, if the court is happy or satisfied, impeachment proceeding will not happen. Okay, if let's say, for example, if the court is not happy, then they will organize a so-called war down. Okay, normally what they will do is they'll adjourn the session and they will have a war down. A war down is that the recording officer will come to give statement, said that this statement was given voluntarily. Saya tak paksa Andy cakap apa-apa. Dia cakap dengan suci hati. Something like that. Okay. And I trust that this record, the statement is recorded in a proper manner. Okay. So if let's say, for example, the police had already, the recording officer from the police force okay, had give strong evidence. At the end of the day, the DPP succeed in doing the impeachment proceeding. Then what the court will do is the court will give ruling, will give, okay, impeachment sustained. So this guy and this punya whatever testimony that he gave in the court will be totally erased, as he never comes to the court. So this is how. Because at the end of the day, you must remember that the accused will need to cast a reasonable doubt to his case. if Andy's punya testimony persists, that will form one reasonable doubt. So that one is not fair to the prosecution, isn't it? So this is how. Secondly, there is a breach of statutory right to cross-examine. Okay. Whenever uh the DPP finish examination in chief, then it is our turn as private lawyer lah, we call defense counsel to stand up to cross-examine the witness. So this is a so-called um uh an indispensable component of a fair trial. The purpose of cross-examination is to discredit whatever evidence given by the witness. So this is the role of defense counsel. So if the learned magistrate interrupt the defense counsel or even stop him from doing so, he already said in his in his open verdict say that Andy's witness is doubtful. We will not act open you, so you do not need to what we call cross-examine him further. He had already prejudiced the case of the defense because by right I deserve to cast a reasonable doubt on behalf of the accused, but such right is being denied. So how? So cumulatively, these two improper approach by the learned magistrate had caused miscarriage of justice. So when you finally put forward your prayers in the submission, the appellate submission, you must pray that the accused should be released, acquitted lah. Or in alternative, what normally will happen is that you can ask for a retrial but under different magistrate. Okay, so by answering so, you can actually get the reality into answer sheet. So this is what happened. And at the same time, you can put in your discussion about impeachment proceeding and also the right to cross-examine the witness. So this is your appeal. Okay. Second, discuss about war down. Okay, war down is a trial within a trial lah. Okay, so what is a trial actually? A trial means we have to call witness, and this witness itself will be subject to EIC, CE, and also RE. And along the way, there will be tendering of evidence. The exhibits, if it is marked by the court, or there will be some evidence marked as ID if it does not satisfy the, for example, it was caught by hearsay. Okay, it will be uh, deemed as ID first. Okay, so this is a trial. But whereby in situation where the court feel there is something fishy with this particular testimony of a witness, they will conduct a collateral or a side-by-side trial to determine whether this is particularly when there is a caution. Okay, if you look at section 24 to 27, the ITP issue, inducement, threat, okay, those issues, if there is, it raised the doubt of the court, this war down, this war down can actually be triggered. It is not just limited to impeachment proceeding. Okay, because why they need a war down is because to determine whether I can still rely on this witness to give me the truth as the finder of the facts. The judge themselves must be clear and they must also be happy with the testimony given by a certain individual. Okay, so far can understand the word down. Okay, so in conjunction to that, this particular word down itself, isn't it? The evidence given is recorded separately. Okay, unless, for example, the impeachment proceeding is upheld. Okay, for example, both parties actually does not enjoy the evidence raised during the war down itself. Okay, and it cannot be used for whether you can win the case or lose the case. Okay. And another thing is that when the court give the ruling for that particular war down, isn't it? You cannot appeal. The matter just end there. Okay. So now this one is very important. Yeah. So this procedure, the ultimate purpose is to help the judge from potentially tainted evidence. Okay, so whenever there is a doubt, any party can raise to have a vote doubt. Okay, and second, we talk about real evidence. Real evidence sometimes we call material evidence. Okay, for example, blood-stained knife, drugs, stolen items, or whatever that used to commit a crime will be physically brought to the court so that the judge, the witness, as well as the accused can perceive, can see it, can touch it. You can touch it, no problem. Okay. So this is real evidence. Okay. Actually, the Evidence Act itself do not have a so-called express definition for real evidence. But somehow Section 3 gave an inclusive um, definition of evidence, meaning that the court can stretch the forms beside oral evidence by the witness or the documentary evidence. You can also bring physical thing to see it for real. Okay. And section 60 subrule 3 actually empowers the judge to evaluate the material thing for inspection. Because often than not, the why we need to bring this real evidence is that, okay, if you said I, for example, have murdered my wife with a knife, and the knife was found at the crime scene with blood stain. If this particular murder weapon is not brought to the court, your chain of evidence will be broken. The defense counsel will smartly say, okay, you look at your charge sheet. You say that Dr. Chi killed his wife with a knife. So tell me, where is the knife? Finished. You don't have the knife. You just have the photo. The defense counsel, the next question will ask you, so this is a photo, isn't it? So this photo will not actually kill the wife, correct? Your case crushed. So the great strength of this real evidence is in immediacy. Okay, so that the judge, in fact, everybody in the gallery could appreciate lah. Okay, what is it? And one particular case here is Li Liu. Okay, and so it established causal link, like I've told you, and furnished corroboration. Corroboration here means supportive evidence to help to fulfill the best evidence rule. Okay. And most importantly, the chain of custody. Okay. But eventually, even though this is a real piece of evidence, but still the court or the judge itself retains the right whether to accept or to reject this piece of evidence. Okay. I think no need to discuss so much about those essay type question. Okay, we move on to question 3. Okay, this carry a full marks of 25 marks, 25 marks. So whenever you have this sort of big marks question, what you need to do is what, you have to analyze the question well so that your answer is seriously correct. Otherwise, you get the whole question wrong. Okay, so this question I underline, you must discuss the evidential issue raised, and Barbara is about to sue this cake bake. Okay, so I suppose you read this short story. This is basically what's happening. What happened? Barbara, the sole proprietor of Barbie's bakery, is actually commencing or contemplating a legal action against Cake Bake Sdn Bhd for breach of agreement. Against this is the breach of contract cause of action. So regarding to heavy duty oven purchase. So to succeed her claim, because you must now appreciate that you must be very practical in answering the question. So what you need to consider. So the question did not ask you about legal burden, standard of proof, but rather they ask you what are the evidential issues that could arise. So it gives an impression more larger, I mean a larger scope must be covered in your answer. Okay, so to succeed her claim, I will put it this way. Barbara must overcome some evidential challenges, including, okay, the following matters below. Number one is to discharge her legal burden of proof and also meet the standard of proof up to balance of probability. Okay, primary issue now, okay, if you look at the facts, you want to draft so-called a good story and good advice to Barbara, you must start with the cause of action. Again, this is relating to breach of contract. Primary issue now, do we have a contract? Correct? So now we do have a contract. Now we have a contract, but the contract lost, was stolen, allegedly being stolen when this Barbara is going to one cafe, okay, on her way to visit Cake Bake. Okay, so under Section 91 Evidence Act, when the terms of the contract had been written down, reduced in document, you cannot have any other evidence except to bring to the court, look, this is the agreement signed between Barbara as well as Cake Bake, and this is how I prove the existence of the contract. But now the issue is, okay, we do not have the original evidence. The original copy of this particular agreement had been lost, gone lah. Okay, so if you cross refer to section 62 and also section 64, all the evidence, all the agreements, all the documents, if it challenged by the opponent, by right, you should let the court to inspect the original copy. You get me? Okay? But now, since Barbara briefcase is now stolen, original document cannot be produced. So how you want to admit this so-called to prove there is a existence of contract? So you can rely on secondary evidence. That means to say you can admit photocopy, scan copy of the agreement, provide you satisfy that you have done necessary uh, efforts to locate the primary document, but still you have find it. I mean, you try to go back to the cafe and keep finding, but you can't locate it. Okay. Otherwise, if you have a digital version of this particular document, you can tender it by Section 90A of Evidence Act. Okay. And this is Syarikat Jengka against Abdul Rashid. Okay, you must give your supportive evidence, police report is important, okay, regarding to the theft of the incident lah, so-called lah. Okay, and second, you must prove you have done, Barbara has done the contractual obligation. So the next challenge that Barbara would have is to prove the 25,000 deposit payment, because Ken is now disputing Kate Beck never received it. So as a plaintiff in this case, Barbara bears the legal burden to prove this payment as asserted by her. Okay, but luckily she had a computer generated receipt. So this is able to tender by Section 90A of Evidence Act, provided you can produce a certificate. Okay, you just tender this Section 90A Subrule 2 certificate, and according to case of Nana Segaran, this document will be admitted as exhibit by the court, and the court would think Barbara had paid to kickback until rebutted. Okay, this is how and next, what you need to prove is that kickback breached the contract, isn't it? So how this kickback breached the contract is that they did not provide the agreed training to the staff. So initially, Ken had actually promised to provide training as part of the contractual terms, but this is not fulfilled. Okay, so how do you want to prove this? This is how Phil's report and CCTV recording on the facts you can manipulate. So CCTV footage is a form of computer generated document. So this is admissible, okay, under Section 90A, and referring to Ahmad Najib Arif's case lah. Okay, so CCTV admit for what? To prove identification that Phil did come, but unfortunately after the installation, he did not provide training. Okay. Other than that, you must also know that there is a report, isn't it? But this report, if you read the question by heart, you'll realize that this is just an installation report. So my question put back to you is that, would this report be helpful for your breach of contract case? This report is just saying that, okay, I have installed this oven in Barbara's shop, and then that's it. But I did not mention, I did not provide, I feel did not provide training. So this one, somehow or rather is quite tricky, The probative value of this Phil's installation report, I think is not too high. Okay. And the next issue that you can see or detect from the facts is that Phil's left kickback. So we want to talk about or elaborate further about the admissibility of the report and also comparability. Okay, you see, Phil's departure from kickback itself had some bearing to Barbara case to establish that Phil did come, but what he did is only to install the machine, but he did not provide training, isn't it? The best thing here is actually to ask Phil to come to give oral testimony under oath. That means to say dia kena angkat sumpah, and then you ask him, okay, this Phil, apakah prosedur anda datang hari itu? He will just say that I have installed the machine, but I did not provide training. So if it will be coming out from his own mouth by oral testimony, this piece of evidence will be very helpful. Okay, so I relate this to section 118 issues about the competency as well as the compellability of this witness because it is within his personal knowledge. But let's say if Barbara cannot secure Phil's attendance, an alternative evidential route is about the said written report. But this written report, you can say lah, okay, it could be emitted under section 32 subrule 1 subrule B as per the statement made in ordinary course of business. But unfortunately now the person cannot come to court, okay, and I mean Barbara had tried to locate Phil but still couldn't get. Okay, take for example, okay, if let's say you cannot admit under section 31 subrule 1 subrule B, you can still go with section 73A to admit this particular report. But eventually you must also look at the weight attached to this report. Okay, you can make some challenges, say that this report itself is concerning to the event of installation. It does not really help to prove there is a breach due to lack of training or default of giving training to the staff. So this is how you justify lah. So different part of rules will be used. And another section I think you need to mention, if you use section 32, okay, the hearsay exception is that Barbara will need to satisfy a few factors because otherwise, okay, section 32 is like that. It makes things easy for a person to rely this section so that the maker will, even though the maker did not come to the court, this evidence is still valid, isn't it? It does not caught by the documentary hearsay. But now the problem is if let's say this section 32 is subject to abuse, how? So the court had put in the criteria for you to satisfy. This one, Barbara would need to adduce evidence to show that, you see, I have tried to contact the workers of Kickback, the friends that is close to Phil, and then I have tried to hire a private investigator to find him across in Malaysia, but still could not get. I don't know where is Phil now. So this is how you satisfy this criteria. Okay. So same thing goes with section 73A. Okay, there is certain criteria or condition that you need to fulfill. Okay, you look at section 73, subrule 1, 73A, subrule 1, subrule B. Okay. So other than that, you will also have issues of oral representation. Okay, oral representation on part of Ken. Okay, Ken said two things, isn't it? That the this oven is used by a famous chef, and second thing is the deposit could be refunded if Barbara is not satisfied. The chef part, I think, is not so relevant to our current claim because no proof to rebut this oral representation. So Barbara would like to rely on this particular one, that the deposit could be refunded if she's not happy. So now what we have is the agreement already reduced into black and white. So Thorough evidence rule was set in to bar any extrinsic evidence from adding, varying, or contradicting that particular document. So, in order to help Barbara, we need to see whether any exception to Thorough evidence rule apply in this particular case. Okay, there are two possible routes here. One, you may rely on section 92 subrule C to say that this could be a condition precedent. This is how Barbara is being induced to enter into the contract with Kickback, okay? Without this condition attached to the the written agreement, Barbara would not even consider to enter into this agreement. So this is condition precedent. But on top of that, Barbara can also argue both agreement, the written one, as well as there is one oral collateral agreement. Both exist side by side. So there is two agreements entered. Okay, one is the written one, which she lost lah. Okay, the second one is the oral agreement. Okay, in between uh, the the defendant and also Barbara. So this is how you argue. But eventually, I think you will like to submit that condition precedent is more probable in this case. Okay. And last but not least, if you could read the question again, you see, specifically uh, in the first paragraph, that tells you what is the legal capacity of the parties. Okay, because you see, if you make out issues, there is not much, but they give you 25 marks. So I'm just thinking, but of course, this answer is not endorsed by LPQB. I'm just thinking, legal capacity authority should be briefly argued because this is a contractual claim. If you fail to prove to the court that, let's say, Barbara has legal capacity or Kickback has the corporate capacity as a company, Sendirian Berhad, isn't it? And whereby, if let's say it is challenged, can did not have the authority to enter into agreement. If you have fail to establish this legal capacity, the whole action will be defeated. Okay, that means to say you can't even, you'll be struck out from the beginning. Okay, so you give a conclusion based on what you have discussed. Okay, this is how it goes. Okay, yeah, last question that I want to discuss, question number 4. Okay, question number 4 itself, okay, you look carefully, okay, and you have to advise DPP on several issues. Okay, this is a rape case for young children. Okay, so if you look at this question and if you do not grasp good familiarity with these two acts, this one, evidence of child act as well as SOCA, the Sexual Offense Against Kanak, of offense against this Children Act 2017. Okay, you will be having problems in answering this question. I'll be very honest with you. If you just answer based on section 118, the competence issue, and also the general proviso, how the child is being tested to give sworn or unsworn, corroborated or uncorroborated testimony, probably you will not even score, not to say pass lah. I don't think you'll get marks, for this sort of question, because this question is the one that I told you is a highly specific question. Okay. So be clear. So if you want to advise DPP, you must tell her or tell him there are some interwoven of a few law. Number one, Evidence Act, the General Act, Penal Code, okay, Section 376 probably for rape, CPC, and these two, Evidence of Child Act as well as SOCA. Okay, now you see how you apply the law and how you must let the examiners know that you are aware of this law is that you see both of the victims are now 6 years old. Okay, they are actually deemed to be um, the child witness under the meaning of Section 2 Evidence Act. Okay, means any person under the age of 16-year-old. If, let's say, for example, this particular person, less than 16-year-old, is called to give any, is called to give evidence for any proceeding in the court, this rule will automatically prevail because Evidence Act, I think I said it from the beginning, this is a general statute. But based on the doctrine of generalia specialibus non derogant, the specific statute which govern how the children's witness should probably how their witness is given, how we are going to rule and help them to give evidence in the court. This specific ECWA will prevail over Evidence Act. Okay. And second thing you must look is that this is an offense of sexual offense against children. So SOCA itself is offense specific. If you look at the schedule behind the SOCA, it clearly stipulate that rape is under its coverage. So section 17 and also section 18 of SOCA deals with the competency as well as uh, the judge can convict and accuse without the need of corroboration in his testimony. That means to say, if a child comes to court and say that I was being raped by what's the name? Psycho. Okay, this is her statement. Even though this statement stands alone without any supportive evidence or other related testimony, for example, from the child's mom say that she cried a lot after the day. This will be sufficient, without corroboration, and Sokai could be convicted. So this is how the court is trying to help vulnerable children. Okay, you must remember, and ECWA is more procedure specific. Okay, that is to say that you can use video. The child can be exempted from coming to court in this sort of particular uh, uh, statute. Okay, so for a very large extent, it helps to prevent the child from getting secondary trauma by the defense counsel. Okay, so therefore, if you look at the offenses and you look at the age of the victims, Lily and also this Minnie, you must advise DPP to depend heavily on ECWA and also SOCA, okay, in conducting her matter lah. Okay, so general provision still stands. Still stands. Section 118 Evidence Act still stand. Why I say it is still stand? Because there is one proviso in ECWA as well as SOCA say that if there is no conflict between Evidence Act as well as CPC with it, so this proviso can still be used in the court. Okay, so Section 118 no contradictory with the specific act, so that's why it still stands. And Section 17, SOCA, you need to know that this provide a rebuttable presumption. Rebuttable means boleh dilawan, challengeable presumption. Okay, even though this child, Lily or Minnie, can give evidence and the court will automatically presume, memberi anggapan bahawa saksi ini adalah seorang saksi yang kompeten. Tetapi, kalau if let's say the defense raise, tengok dia ada kecacatan mental, dia punya development, the growth is abnormal, mentally challenged. So if let's say, for example, there is sufficient evidence from the defense, this anggapan itself can be thrown out. Okay, the judge will still need to conduct a preliminary. I will just say a preliminary lah, not full down. Okay, a preliminary inquiry. How the judge conduct is that first the judge normally very friendly. They'll ask, adik awak faham bahasa Melayu tak? Lepas tu dia akan tanya, awak tahu umur awak sekarang? Belajar di mana? And then what's your hobby? They'll ask, then subsequently they'll go into the case. Tahu kenapa adik hadir ke mahkamah hari ini? Kenapa on video hari ini? If the child shows sufficient intellectual to answer those questions, then the court will accept this child as a competent witness. Okay, like this. And other issues that DPP would deal with, okay, because the scope is a bit broad. It's not just comparability. Okay, is how to give evidence. As I have shared with you, relevancy is one factor, admissibility is one factor, weight of this particular evidence, as well as you must look at the mode to present the evidence, isn't it? So this SOCA is actually silence on courtroom logistic, but ECWA, as I have told you, this is procedure specific. Means the court can actually ask the victims to give evidence by live video. Okay, so the girls do not need to face the accused, and most of the time there will be a person like an officer accompany from the Jabatan Kebajikan Masyarakat, accompany the child if let's say the child is really a tender age lah, okay, accompany the child to give evidence, assist her and make sure she understand the language like that, okay. And subsequently the girls, even though you said so already, because SOCA said that Section 18 said that the court can convict an accused without any requirement of corroboration, correct? But somehow or rather, if you have corroboration, you better use it as a DPP. So this is good. Corroboration could come from the Dr. Fifi because just about five hours apart, and both of the child had seen Dr. Fifi in the hospital and they told what happened to them. So this piece of information will fall under res gestae. Okay, this one we'll discuss later lah. Okay, so SOCA actually displays the rigid corroboration rule under section 133A. Okay, so conclusion is that read through the lens of Generalia Specialibus non-derogant, SOCA governs the admissibility and legal sufficiency of girls' evidence, while ECWA governs the procedure and protections, okay, so that the evidence can reach the court. So actually, these two laws here protect children, okay. You must try to understand now, children, women, those are typical vulnerable individual that will be subjected to violence. So our parliaments really do a lot of efforts lah to help them. Okay. And B, the evidential issues arise of Dr. Fifi's evidence. Okay, one thing is that you must read the question carefully. Don't you just based on you read doctor only, oh, he must be an expert lah, like that. On the facts, I would say Dr. Fifi's play a dual function, dual role. One, she is an expert for the findings, the tear in the vagina. Okay, this is her expert opinion. Assume the role as an expert witness. Second, she can also be a factual witness to tell to the court that I heard from the girls that ada cacing masuk, something like that. Okay, so in order for you to elaborate your case better, a fact is any condition or occurrence that directly perceived through your five sense, your smell, you listen, you see, you touch, and you feel the temperature, something like that. Okay, whereby opinion itself is what you think. This is not facts, Okay, opinion normally is dalam pendapat saya. In my opinion, I feel that this will be the case. Okay, so Ku Hai Chiang is a good case that distinguished facts and opinion. And general setting is that a witness can only testify what are the things he or she personally perceived. Okay, that means facts only lah. He cannot tell evidence because it will be caught under the this what we call the this is inadmissible. Okay, because evidence itself will not help too much the court. Everyone can give evidence about what they think, but what they see is actually reflecting the truth in general. Okay, so two pieces of discussion that you need to discuss. First is about the opinion. You can use section 45 Evidence Act to justify. Okay, but don't just put the general statement. Here, Dr. Fifi, if she act as an expert in the court, number one, the DPP will need to establish her professional qualification. For example, if she has a medical degree, is she a specialist, is she registered, and how long is her experience and whether she has given any evidence in the court before. Okay, so after establishing the evidence, and she will tender the report. The report will actually draw the part of the genitalia and show there is some tear, fresh tear over the vagina, which is consistent with the recent penile penetration as described by one of the victims saying that touching muscle. Okay. And also another part is that if you relate to the fact the head is injured, isn't it? Lily's head is injured. Is the name correct? Lily's head is injured. Okay. So these are the things that will be in the um, medical records. Medical report, sorry. Okay. It will be. Okay, Lily heads injured. Okay, so this is in line with case of PP against Lin Lian Chen. Let's say, for example, this is a criminal case. So expert report is also subjected to procedural rule. As far as it is possible, in criminal case, you try to cite section 399 of CPC. Okay, if let's say this come in a civil case, this is section order 40A of rules of court. So this one determine the manner to tender this sort of report to the court, So very important. So you just say section 399. If let's say, for example, if the DPP will not require the attendance of Dr. Fifi to the court, then what DPP can do is to give this report about 10 days to this defense counsel so that the defense counsel can have time to study this report. Okay, if let's say the defense counsel insists to call the what we call Dr. Fifi to come to court, then the defense counsel can actually write into DPP to mention his intention to do so. Okay, so otherwise, there sometimes to dispense the need of so many people coming to court. So this is one procedural rule that is applied by the court to dispense the attendance of expert. Reason being why, you see, this Dr. Fifi's, she would have a lot of case to attend in her clinical practice, as well as probably she has become the expert witness for multiple cases, So if she keep on attending to court, then what is her devotion in the medicine here in her own field? So not logic, isn't it? Okay. But however, you must look at the facts. I think calling Dr. Fifi is a must because Manias want to raise defense of alibi. So, and some more, there is some this one, the res gestae thing, because Fifi at the same time will be used by the prosecution to say that the charging thing, okay? The charging and also painful thing, okay? Winnie the Pooh did painful thing. So this will be a form of factual evidence, okay? This will come in a manner of res gestae under section 6 because it is made by the victims in a very spontaneous manner and contemporaneous to the traumatic event. So this is just 5 hours apart. The whole thing is new, and res gestae should be able to be applied for this statement. And remember, when you use section 6 or res gestae, this is a hearsay exception. Okay, and the court would think that this is a safe evidence. That is because if it judged at the surface of evidence, the victims has no time to think. Remember, no time to think, to fabricate, to make the story up, to concord, to set somebody up. Then normally the court will accept the truth of what is that statement. Okay. And then subsequently, you talk about a little bit about the probative value. Okay. So last question is about the burden and standard of proof of Manian's defense of alibi. Defense of alibi means what? Defense of alibi means that I am not at the place of crime scene that time. Is therefore, since I'm not there, it is not me that commit the crime. Okay, so the relevancy part, you can see section 11 sub-rule B and also illustration A of Evidence Act section 11. Okay, it's a good example. Okay, and Manias, in order for him to raise the what we call the defense of alibi, he cannot simply just tell like that. He will need to bear the legal burden. Okay, it's not evidential, it's legal burden. Okay, he has to bear the legal burden to exert this particular statement. Okay, he must tell the court where am I. Okay, what am I doing that time, and then any evidence that can support that I am not at the crime scene. Okay, so he has to get some friends to come to give testimony. Okay, yeah, for example, the friend of Manian will say, okay, all the time on that particular day, Manian was with me. I did not see him moving away. Okay, or he can produce CCTV footage to support that he's there in the house for the whole day, bus ticket, or any other relevant evidence. Okay, as simple as that. If that threshold, this threshold of balance of probability is crossed, okay, the evidential burden will shift back to prosecution to prove every single element of the charge that Manian raped these two girls beyond reasonable doubt, marked against PP. Okay, and okay, so this is the same. Okay, even if let's say, for example, this defense of alibi succeed, but PP, the prosecution will still bear the legal burden to prove its case beyond reasonable doubt. Okay, and one more procedural requirement, as this is a special type of defense, isn't it? So section 402 sub rule A apply. Whenever the defense would like to raise this particular defense of alibi, he must notify the DPP, and DPP will actually let the police know to probe into the alibi issue so that he cannot fabricate. He cannot suddenly say that, okay, this friend had met me. The police actually will call this friend to give rakaman percakapan, so less chance for the defense to get escape just by using the defense of alibi. It will be too simple for the defense to do so without certain rules and criteria, okay, to stop him from doing so. Okay. All right. Is there any question? I think I forgot to ask this important question. I just go on with my my this one, my class.